Hello, welcome to this video on theft, which is part of criminal law and property offences. So our aims under this video are to learn and state the definition of theft, explain the actus reus of theft, explain the cases which illustrate these actus reus elements, explain the mens rea of theft, explain cases that illustrate the mens rea of theft, and of course, as you will have to do in every question, analyse the problem question and be able to apply the above rules to the situation to reach a sustainable conclusion, which will be dealt with in a separate video. So the definition of theft then contains all of the elements of theft, so it's really nice. Once you've remembered all of these elements, you're able to just list them and of course apply them as you would once you've separated them into actus reus and mens rea elements. So section 1 of the Theft Act 1968 gives us a definition. A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it. And so what we can do is broadly separate these elements. We've got appropriation of property belonging to another, or the actus reus elements, and mens rea. Section 2 deals with what dishonesty isn't rather than what dishonesty is, and also section 6 tells us what intention to permanently deprive is. Now, in essence, what we've got here are interpretation sections, and what they're doing is outlining what the definition means. So we are now, as ever, going to deal with each of these elements in turn, exploring how each element is satisfied in addition to cases to prove the points. So we will begin with appropriation, which is dealt with under section 3 of the Act. Now, it can get a bit wordy. Of course, we're going to deal with it now. We're going to explain what it says, what it means, and in a nutshell. So appropriation in section 3 of the Theft Act states under section 3 subsection 1, any assumption by a person of the right of an owner amounts to an appropriation, and this includes where he's come by the property either innocently or not without stealing it, and any later assumption of it or right to it by keeping or dealing with it as its owner. And section 3 subsection 2 tells us, though, where a property or a right or interest in property is or purports to be transferred for value to a person acting in good faith, then no later assumption by him of those rights which he believed himself to be acquiring will amount to theft of property and therefore appropriation. So what we mean by that is, an appropriation means doing something with the property that the owner has a right to do, but which no one else has the right to do without the owner's permission. Now, this could include selling, keeping, damaging, or even destroying the property. It's not limited to physically taking the property, and of course it doesn't have to occur by taking the item deliberately. So the second part of section 3 says that appropriation covers situations where someone gains property without stealing it, but later assumes the right of the owner. So for example, if you lend a law book to your friends, then you ask for it back and they refuse, no appropriation has taken place there. If both parties have acted in good faith, but if not, then an appropriation may have taken place. In a nutshell, an appropriation includes taking property, destroying property, using it in an unauthorized way, selling it, offering to sell it, or refusing to return it after coming by it legally, even when consent appears to have taken place. So we can look for any of these in any situation. Usually, this isn't a problem when you're applying the law. It is obvious in which way the appropriation occurs. So like in Morris, in this particular case, we have a defendant who switched price labels. Now only the owner has the right to do this, and so therefore appropriation had taken place. In Gomez, Gomez was the assistant manager of a shop, and he persuaded the manager to sell electrical goods worth over £17,000 to an accomplice and to accept payment of 2 cheques, telling the manager that they were as good as cash. Now the cheques were stolen and had no value, and Gomez was charged and convicted of theft, and the House of Lords decided an appropriation had taken place. So in this case, we got the appropriation were taking the fridges or giving the fridges for cheques which were worth nothing. In Lawrence, an MPC, so the Metropolitan Police Commissioner, an Italian student give 52 pence for a taxi ride, and he was offered the defendant a £1 note, but the defendant said more money was needed, so he took a further £1 note and a £5 note from the student's wallet. Now, although the Italian student appeared to consent to this, there was an appropriation even when this owner had consented, because in essence, had only consented to the amount due, rather than the whole amount which was taken by the taxi driver. In Hinks, a very complicated case, but this sort of deals with inappropriate gifts and sort of taking an advantage of a person. In this case, Hinks had befriended a 53-year-old man of limited intelligence, although he was mentally capable of understanding the concept of ownership and of making a valid gift. But between April and November in 1996, she persuaded him to give her a television set and to withdraw £60,000 from his building society, which was then deposited in the defendant's account. Now, Hinks argued the money and goods were either loans or gifts, and therefore not been appropriated by her, but despite this, she was convicted of theft of the money and the television. Now, the Court of Appeal upheld this conviction, but allowed an appeal to the House of Lords on the question of whether acquisition of an indefeasible title to the property could be classed as amounting to an appropriation, i.e., was there appropriation even though the property was a valid gift. Now, on a 2-3 decision in the majority in the House of Lords, it was decided there was an appropriation. So this, of course, will be followed in future cases. A couple of other cases to look at were Vinal, Pitherman Hyle and Atakpur and Abrahams. In Vinal, this concerned a bicycle. So two young men were out cycling when they encountered the defendants, who subjected them to verbal abuse and punched one of the victims of his bike. Now, other threats were made and they chased them, and the defendant carried off the bike and abandoned it 45 minutes later by a bus stop. And on appeal, it was decided that either the taking of the bike or an abandoning of the bike could be an appropriation, because only the owner has the right to do both of these things. In Pitherman Hyle, the defendant sold furniture belonging to another person, and again this was held to be an appropriation. The offer to sell was an assumption of the rights of the owner, and appropriation took place at that point. Now, it didn't even matter if the furniture was removed from the house or not. And in Atakpur and Abrahams, this involved the issue of appropriation of where it occurs. Now, using false papers, the two defendants hired some expensive cars in Germany and drove them to England to sell them there. Now, they were arrested on their return to England by two customs officers and subsequently convicted of conspiracy to steal. Now, they appealed on the ground that they had not committed an appropriation in England, and this was allowed. And this is largely because German law is slightly different to English law. So once we dealt with appropriation, we need to consider what is the person stealing, what is the property, and this is dealt with under Section 4 of the Act. So the definition of property according to the Act is: property includes money and all other property, real or personal, including things in action and other intangible property. So what you should do is consider what all of these things mean. So when we talk about money, that is cash money. So it's not money in the bank, because that is something you can't physically touch. So it's money that you can touch. Now, real property concerns land or severing part of land. So this could be things like a tenant fixture, so something attached to land. Things in action are things like rights which can be enforced by another person. So it could be a debt or money in a bank account or shares. Again, things which need something to be enforced and things which need action on them. And then, of course, we have other intangible property, so things like gas in a container, electricity, copyright we can have as well, patents, trademarks, intellectual property. These are things you cannot touch but can be stolen. So, of course, it excludes land or things forming part of the lands severed from it, such as harvested crops or picked flowers, but some exceptions have been when the defendant is in certain positions of trust and appropriates the land or anything forming part of that land by dealing with in breach of the confidence reposed in him or her. So we've got a situation where there's confidence and they abuse that confidence and take some land. When the defendant is not in the possession of the land and appropriates anything forming part of the land by severing it or causing it to be severed, or it's been severed. So, for example, knocking down your neighbour's brick wall and carrying away the bricks. And of course, lastly, when the defendant is in possession of the land under a tenancy, appropriates the whole or part of any fixture or structure let to be used with the land. So if you rent a premises, for example, and when you leave, you remove a fixture or structure, for example, the toilet, something which is firmly attached to the land. So some things which cannot be stolen, and therefore, because they're not property, are under Section 4.3, things like wild mushrooms. So any wild flowers, fruit or foliage, provided it's not done for commercial purpose. So if the plant is cultivated, then it could be theft, it could now be property. In addition, under section 4 subsection 4, a person will not commit theft if he captures a wild animal which has been tamed or reduced to captivity by the defendant. Now the main implication of this section is that poaching doesn't normally fall within the offence of theft. It doesn't mean it's not an offence, it just means it's not theft. So of course you probably couldn't go and steal a horse from some land or something from the National Trust land, for example. Now some examples, then some unusual case examples of things which can be considered property are in Welsh blood and urine samples. So the defendant here was convicted when he removed the urine sample he had to give for analysis by the police. So he gave his urine sample and they took it back so it couldn't be analysed. That is theft. Oxford and Moss tells us that information can't be stolen. Now this was in Liverpool University, a proof of an examination paper. They read the contents and handed it back. Now it was held that information cannot be stolen if it's not tangible, and the student couldn't be convicted of theft. But in Akbar, if you take the actual exam paper it shows in this case, then you can it can be classed as property because it's the physical papers, so it contrasts with Oxford and Moss. In Edwards and Stacey, the defendant stole pig carcasses from a farm. Now these dead pigs were still the property of the farmer. In Kelly and Lindsay, body parts preserved for scientific examination were stolen. Indeed, Kelly was a sculptor in this case who asked Lindsay to take part in Royal College of Surgeons where he worked as a lab assistant. Now Kelly made casts of the parts and they were convicted of theft, and this upheld in the Court of Appeal. Now the body parts were property as they'd acquired different attributes by virtue of the application of skill, such as, for example, dissection or preservation techniques for exhibition or teaching purposes. So they'd acquired properties. That's why they were held to be property. In Cone, the defendant was an accountant and part of his job was to pay checks to pay off companies' debts, but he paid some of his own debts off and he was guilty of stealing a thing in action. So this check, this thing which could be enforced, and of course it was money from the bank and it was a thing in action. In the Attorney General of Hong Kong and Chan Nai-kyung, an export quota for textiles was considered to be an intangible property which could be stolen, and this enabled the director, Chan Nai-kyung, of a company to be convicted of stealing his company's property when, without authorization, he sold his company's excess quota for a grossly reduced price to another company in which he had an interest. It was held that this export quota, the right to sell textiles, was an intangible property. He undervalued it, and that was the appropriation. So we're looking at the gap between the reduced price and the actual price. So the weird and wacky ways in which they could be considered property have just been explored through case law, but of course it could be almost anything. Again, this isn't usually an issue in the problem question. One thing you may have to analyse though is the section 5, this belonging to another. And this because the rules are a little unusual at times. So we're going to consider section 5 belonging to another. And what the Act tells us is property is regarded as belonging to any person having possession or control of it, or having in it any proprietary right or interest. It can therefore belong to more than one person at a time, and the person can be guilty of stealing property belonging to himself. And there becomes the unusual part. So we've got some situations where the property belongs to another, where the defendant receives property with the expectation of doing something with it, or has an obligation to do something with it. So for example, we're going to see a case in which being given money for bills or money to give to charity and then using it for their own purposes, that is theft under section 5 subsection 3. Now where the property has been obtained by mistake and restoring of the property is expected, this is another way in which it could belong to another, or when another person has possession or control over that property, or when another has a proprietary right or interest in that property. Now it can be, as we say, it belongs to more than one person at a time, and therefore you can be guilty of stealing something that you do own. So in Wayne, the defendant organised charity fundraising events from which the money was paid into his own account. Now he was unable to account for £2,800, and in this case it was held he had an obligation to pay the money to the charity, so it belonged to another. In Davidge and Burnett, The defendant received cheques from flatmates to pay a gas bill. The property did not belong to her, as she was under a legal obligation to use the proceeds from these cheques for payment of the gas bill. So the money was given to the defendant for a specific purpose of paying those bills, and since it belonged to her flatmates, her alternative use of it amounted to an appropriation. Now in Woodman, in this case the company, the English China Clays, had sold all the scrap metal on the site to another company, which arranged for it to be removed. Now, unknown to the ECC, a small amount had been left on site, and there was no doubt they were in control of the site itself, as they put barbed wire fence around it and had notices warning trespassers to keep out. The defendant took the remaining scrap metal and he was convicted of theft, and this was upheld by the Court of Appeal. They had possession or control of the metal, and therefore it belonged to another. In the Crown and Basildon Magistrates Court, in this first offence, Rickett, who was the appellant, had taken bags containing items property from outside of a charity shop. He argued that the original owner had abandoned the property and therefore didn't belong to another. But the court ruled the bags had not been abandoned. They were the property of the original owner until the charity took possession of them. Now, in a separate offence, he also had taken items near a bin behind the charity shop, and the goods were still in possession of the charity shop. So in this case, until there's a clear chain of ownership, and that's what this case demonstrates. In the case of the Crown and Turner, number 2, the defendant put his car in for repairs, but then returned after repairs had been carried out and took away the car from the road in which it had been put without informing the garage owner and without paying for the repairs. Now, presumably there was a spare key. Now, his conviction for theft was upheld, and Lord Parker in this case stated that the court is quite satisfied that there is no ground for whatever for qualifying the words possession or control in any way. Is sufficient if it is found that the position from whom the property is taken or appropriated was at the time in fact possession or control. It's clear that in this case the garage had possession or control of the vehicle, and you can steal your own property, and that's what the decision was in this case. Now, in an unusual case, we have the case of Gilks. Now, in this case, the bookmaker gave too much winnings to the defendant. The money was considered to belong to the bookmaker, but we're going to explore why he wasn't guilty of the offence. Now, Gilks placed a number of bets in the betting shop. One of these was on a horse called the Fighting Scot, which didn't get anywhere. Now, instead, the race was won by a horse called Fighting Taffy. Now, the relief manager in this case mistakenly believed that Gilks had backed Fighting Taffy, paid him £106, and Gilks kept the cash, failing to disclose the mistake, and was charged with theft. Now, on appeal, he argued that Section 5.4 did not apply because gambling contracts are not legally enforceable, and therefore he is under no obligation to repay the money. And the Court of Appeal actually agreed with this, and this is true as you might cover when you do contract law. But in most other cases, if you receive money, even innocently, and don't give it back, it will be theft. Now, in the Attorney General's reference number 1 of 1983, in this case, a policewoman had been overpaid by an additional sum of £74.74 by mistake due to an accounting error by her employer, had failed to alert anyone or give it back, and she was charged with theft, but the judge directed an acquittal. However, the Court of Appeal held that this case was covered by Section 5.4, stating that a person should be guilty of theft, even though they'd not touched the money, had merely left it in their account. It would of course be a different matter if the employee really believed that they were entitled to money or was genuinely unaware of the overpayment, but she was aware of it, and so had an obligation to make the restoration. And if there's a dishonest restoration, then all of the elements of theft are present. So receiving money, it can be theft if it's an overpayment, or indeed it can be if you get any other item by mistake, as in Webster. So in this case, an army officer eligible for a service medal was mistakenly sent 2 identical medals instead of 1. He gave the second medal to the defendant, who sold it via the internet. Now, the defendant was convicted of theft, and his conviction was upheld on appeal. The medal had been sent by mistake and therefore was still property of the Secretary of State. So we dealt with the actus reus. Now we've got Section 3, appropriation. We've got property in Section 4 and Section 5 belonging to another. Now, of course, we've got cases which best illustrate, and often exam questions will look to case law for inspiration, and so you should do that as well when you're applying the law. But we then need to consider mens rea of theft. Now, there's been some developments in recent times with the concept of dishonesty, which we'll cover. And then we have section 6, which is intention to permanently deprive. So we'll start with what dishonesty is and indeed isn't. So dishonesty, for starters, is a matter for the jury to decide. So that comes from the case of Feely, which was the decision there. But a statute doesn't actually define what dishonest is, but does indicate 3 situations where the defendant will not be considered dishonest for the purposes of theft. So section 2A tells us, if he appropriates a property in the belief that in law he has the right to deprive the other of it on behalf of himself or of a third person, so we call this belief in the right to deprive. Or section 2B, if he appropriates a property in the belief he would have had the other's consent. Or section C, subsection C, if he appropriates property in the belief that the person to whom the property belongs cannot be discovered by taking reasonable steps. So the belief needs to be honestly held and reasonable, and the tests are subjective. So as long as the defendant in this case believes he has the right to deprive and can show that to the jury, then he will not be considered dishonest. If he proves that he has belief in the other's consent and there's enough circumstances there, then again, if the jury believe it, they can assume he's not dishonest. And of course, the tricky one, belief that the owner could not be discovered under section 21C. Again, it needs to be reasonably and honestly held. So to explore the right to deprive, so section 21A, in this case we have the case of Holden, which proves this point, and the defendant here was charged with the theft of scrap tyres from Quick Fit where he worked. Now he claimed that the other people had taken tyres without the permission of the supervisor, with the permission of the supervisor, and the manager, however, gave evidence that the taking tyres was a sackable offence. Now the jury was directed that the defendant was guilty unless he had reasonable belief that he had the right to take the tyres. Now the Court of Appeal quashed the conviction. They said the person was not dishonest if he believed reasonably or not that he had a legal right to do what he had done. Now the question was whether he had an honest belief that he was entitled to take the tyres. Therefore then, it's not necessary for the accused to prove that his belief was a reasonable one, providing it's genuinely held, so honestly and genuinely held. In terms of belief that the owner couldn't be discovered under section 21C, of course reasonable steps need to be taken. So if you find a mobile phone, for example, it's usually easy to sort of at least find the owner. You should give it to the police, they could do it. So it's not going to happen in those situations. But if you find, say, an abandoned car with no registration plates, then that it might be slightly more difficult. Now the defendant in Small was convicted of theft of a car. Now he claimed that he believed it had been abandoned because it had been parked in the same place for 2 weeks with the keys in the ignition. Now the jury didn't believe his story, but the Court of Appeal quashed his conviction, as there was evidence that the car had been abandoned and he had an honest belief that the owner could not be traced. Now, we're not to use the Gosh test anymore to establish what dishonesty is. We will talk about the developments of the law, but it is for context, this only. So the old rule under Gosh from the 1980s was where exceptions don't apply, then common law is needed to decide what is dishonest. Now the long-standing test, known as the Gosh test then, was established in this case, and the test was, bluntly, was the defendant dishonest by the standards of reasonable and honest people? And of course the jury will be making that decision. And then did the defendant realise that he or she had been dishonest by those standards? So it's an objective and a subjective test. We don't use this anymore. Following the case of Ivy and Genting Casinos, which was a civil case, in this judgment it was the case outlined that the second part of the Gosh test should no longer be required. So what we mean by that is the subjective element. Do they realise that they're dishonest by the standards of reasonable and honest people? What we have then, it is a star case. This is the test now for dishonesty. So if none of the section 21A, B and C apply, then we look at Barton and Booth, or Booth and another from the Supreme Court. Now, in this case, they said only the first part of the Gosh test is required. So this is now precedent that it's a criminal case, and of course from this point onwards you'll be sitting your exams 2 years after this, so you should be using a new law. So the test is now purely objective, and that is simply Was the defendant dishonest by the standards of reasonable and honest people? So again, the jury will consider, according to all those circumstances, is a dishonesty, and that is the only test. So it's simplified. Don't overcomplicate it by using gosh. Some textbooks and some will still refer to the gosh test. That is now out of date. We use Booth and another, or Barton and Booth. Okay, so once we've established that the defendant was dishonest according to the Booth test, or section 2 in the situations where they're not dishonest, we need to look at the final element in this idea of section 6, is their intention to permanently deprive. So section 6.1 tells us that a person will be taken as permanently depriving the other of it if he intends to treat the property as his own to dispose of, regardless of the real owner's rights, and states this might occur even where the offender is claiming he's only borrowed the goods. And section 6.2 tells us that a person may be regarded as treating the property of his own in cases where he parts with the possession of it under a condition as to its return which he may not be able to perform. So for example, pawning goods knowing that you're not going to be able to redeem them or get the money to do so. So we've got a note with theft. It's a specific intent offence, which means we cannot recklessly commit theft. So we're going to be recklessly dishonest. We can't recklessly intend to permanently deprive. So it is on the prosecution to make sure beyond reasonable doubt that these issues are satisfied, and it is intent specifically. Also, conditional intent will not suffice. That might be an attempted theft, but again, we'll look at that in a separate video. But ultimately, there are two aspects. Okay, section 6.1 tells us disposing of the property regardless of the other's rights, or a borrowing or a lending, making it equivalent to outright taking or disposal. So in Raphael and others were convicted of a conspiracy to rob the victim by forcibly taking his car and then offering him the opportunity to buy it back from them. Now the question arose whether this could amount to robbery, or whether, since the victim would get his money back, albeit by having to pay for it, or get his property back, by having to pay for it, there was no intention to permanently deprive, and hence no theft. And the judge in this case suggested it was harder to find a better example of such an intention. One way or the other, he's going to get his property back or lose his money. Both things are property, and there is, of course, intention to permanently deprive the other of it. Now, in DPP and Lavender, the alleged theft here concerned 2 doors which the defendant had removed from property being renovated by the local council, and then used to replace 2 damaged doors at his girlfriend's residence, which was also owned by the local authority. Now, the defendant was classed by the Divisional Court of Appeal as treating the doors as his own to dispose of, regardless of the rights of the council, and it was felt that this was enough for him to be convicted of theft. This appears to widen the law in this area, and we've got this idea that it's only the council in this case had the right to move the doors from one property to another. In Marshall, concerns London Underground tickets in this case, back in the days when tickets were issued. So the defendant obtained day tickets to travel on London Underground from travellers who'd finished with them, and the defendant sold the tickets to other travellers. Now they were convicted but appealed on the ground that each ticket would be returned to the London Underground when they'd been used by the second traveller. There was no intention to permanently deprive the London Underground of those tickets. Now, the Court of Appeal upheld their convictions on the basis that the men were treating the tickets as their own to dispose of, regardless of London Underground's rights. It wasn't relevant that the tickets would be eventually returned to the London Underground. Now, in Vellamile, this is a case which is often used to support some key elements when applying the law. But the defendant in this case had taken £1,050 from his employer's safe and claimed he intended to pay it back after the weekend, and therefore had no intention to permanently deprive the employer of the property. Now we're talking the property is the exact note here, the money. Now the Court of Appeal held that he had not intended to return the exact coins and notes, and that therefore he was not properly convicted of theft. So a quick note, in such cases like this, it would be far better for the defendant to contend he was not dishonest, gives intention to replace the money with an equivalent fund. But in this case, it was convicted of theft because the exact notes and coins had been taken. Now in Lloyd, we're talking in a cinema here. So the defendant removed films from a cinema for a few hours, made illegal copies of them, and then returned the actual copies, the films. He argued that since he intended all along to return the films, he had no intention to permanently deprive, nor had he borrowed the films in circumstances made of borrowing, equivalent to an outright taking or disposal. Now, it was held that the value had not gone out of the article since it had not diminished in value, so the goodness, the virtue, the practical value of the films and the owners had not gone out of the article, and therefore there was no intention to permanently deprive. And then we have the case of Eason. Now, in this case, the defendant was in a cinema where the victim had placed a handbag on the floor. He picked up the bag, intended to steal if there was anything worth taking. Now, in fact, there were only a few tissues and aspirin inside, so we put the bag back. Now, unknown to him, the owner of the bag was a policewoman in plain clothes, and a bag attached to her wrist by a piece of thread, and she was fully aware of what was happening. Now, the defendant was charged with theft, but his conviction was quashed to the ground. They had no intention to permanently deprive the victim of any property. And this case is because he had what we know as conditional intent. He would have stole if there was anything worth stealing, but ultimately it wasn't enough for theft because you have to have intention to permanently deprive the item, the owner of those items. So, mens rea of theft, we've dealt with section 2, we start with section 6. These both need to be proven, and the defendant will be guilty of the offence. So now we dealt with all actus reus elements and mens rea elements. My advice would be to always explain the law, the definition first, and do it in this order. And finally, we must conclude in any problem question and in any explanation of the law. And of course, the sentence for this is 7 years imprisonment, and it's a triable either way offence.